there was a work group established and funded by the legislature to look at HOAs and the relationship of boards to their homeowners and with property management companies and with cities and other organizations that are interested in HOAs. The work group has been meeting since September. Since September 10th was the first meeting. They've met monthly through October, November, December, probably into January. The purpose was to study the prevalence of and impact of common interest communities, or CICs, as they're called in state law, and homeowner associations, and how existing laws are regulating CICs and HOAs, how they're affecting homeowners and tenants. And they couch it in the term of affordable housing, but they're much broader in the topics that they're actually looking at. This is the website. If you go to lcc.mn.gov, CIC HOA, you'll get to this website. You can register there to get notices of their meetings. And from there, then you'll get access to minutes, copies of presentations. They produce their minutes on YouTube. You can watch their meetings on YouTube, which I've done. Really, in my understanding, my perception is that this has grown out of repeated complaints that have been placed with the Minnesota Attorney General's office, with some legislators, with city administrators probably, and this, after a number of complaints have registered, that raised the attention of Senator Kristen Boehner and some others in the House and also in the Senate. And the result was some legislation that was passed that enabled creation of this work group. So it's funded by the legislature, it's charged, it has membership, it's responsible for producing a report in February to the legislature. The members represent legislators, boards, homeowners, HOA homeowners, attorneys, realtors, CAI Minnesota, which is the Minnesota chapter of the National Organization of Community Associations Institute. There's a representative from the League of Minnesota Cities, the Attorney General's office, and some other interests, affordable housing. So the meetings, as I mentioned, started in September. They'll run through January, and they produce a report to the legislature in February. So a little bit of background. Prior to 1994, condominiums in Minnesota were governed by these two acts, the Minnesota Condominium Act and the Uniform Condominium Act. Townhomes and other forms of HOAs, as we think of them, were governed basically by their governing documents. There wasn't statute that addressed townhome associations. So they relied mostly on their own governing documents. However, in many cases, the documents were outdated, the language was outdated, important things were omitted, things might have been included that were no longer relevant. And as a result, it was difficult for boards to interpret their own governing documents. It was difficult for attorneys to incorporate or interpret governing documents. Judges, if there was legal action, realtors maybe had trouble, home buyers would have trouble. So all of this led to the creation of work group that got together and through legislative action created the Minnesota Common Interest Ownership Act, or MCIOA, in 1994. And that is the legislation in Minnesota that governs us, governs our condominiums and townhome association and other forms of HOAs. So this became effective in 1994, and it governs all condominiums and townhomes built after 1994. If your HOA or your townhome was built before 1994, you can amend your governing documents to state that you are opting into or you're going to be covered by MCIOA. And then you get the benefits of the statute. And it is widely considered to be beneficial to homeowner associations. A number of things. It mandated homeowner membership and gave them duties and responsibilities. It gave the board fiduciary duties and responsibilities. It gave the boards authority to govern and to administer the financial operations of the HOA. As I said, it was widely considered to be beneficial to homeowner associations. Some of the benefits, it allowed boards to create budgets, to collect assessments, to hold meetings and elections, to maintain and repair their common properties, to adopt and change rules, to contract for services, and to collect unpaid assessments, and to place liens and to move on to foreclosure if that was necessary. And these things were beneficial for HOA boards to maintain their fiduciary duty, which was to protect and maintain the value of their properties. That's why the HOA was established. So there was possibly some disadvantages. It did require master insurance for all HOAs, and as we know now, that's become a burden. It's becoming an increasing burden for our HOAs, the costs. But on the other hand, it mandated insurance coverage so that your properties were going to be insured. It also mandated adequate reserve funds, so that the term adequate is a little bit open to interpretation, but it does mandate that boards have reserves. They have reserves sufficient to cover the future expenses that could be expected in their HOA. It did allow for increases in assessments to cover those costs, and I think it required a financial audit. So these things could be seen as a burden to homeowners, but on the other hand, in the long run, they generally benefit the operation of the HOA. So this is kind of the context. So this work group then was set up to look at how AMCIOA and how it's been implemented over the last 20 years, what impact that's had on homeowner associations and the lives of their members, their member homeowners. So as I mentioned, the chair is Representative Kristen Boehner. Senator Lucero is co-chair. They've been meeting for those months. They do have listening sessions. And by the way, the meetings are open. You can register to present. I was invited to present at the meeting, and I did that on October 26th. And I'll talk a little bit about what I recommended. But they have, you can register, you can make verbal comments, or you can submit written comments to the work group. They did have a listening session on December 6th and 5th in Maple Grove, and December 19th they'll have one out here in Maplewood. There are 2 other locations to be determined. I think they're hoping to have 4 listening sessions. And again, you can register to make your comments at those meetings as well. So the format of the meetings is they have invited presenters, and then they also have opportunities for homeowners and board members to make presentations to the work group. And by and large, the ones that the meetings I viewed and the one I attended, by and large it is homeowners who have had a negative experience, either with their board or with their association manager, sometimes with an attorney, sometimes with the city. But the work group really is hearing a lot of negative experiences from homeowners. And it's my belief that that's not the norm. Most HOAs are not burdened with lots and lots of problems. But of course it is the problems that become verbal and visible, and that's what the work group is hearing about quite a bit. And as I mentioned, I had a chance to speak on October 26th. I said that we are far more alike than we are different. We have far more in common. As members of the board, we want to do a good job. We want to have good associations. And homeowners have a right to benefit from living in HOAs. Both board leaders and homeowners would benefit from more education, better understanding about homeowner associations, how they work, and that policymakers can and should support HOAs. So in my sense, what happened was the law allowed HOAs to be created. They said everybody's going to have a board, and you're going to have boards, and the boards are going to have these fiduciary duties and responsibilities, but nowhere does it say, and these are the ways that you're going to learn how to do that. There's very little education available in an organized way. We offer educational meetings like this. Some association management companies offer those meetings. Attorneys offer those meetings. But it's a very fragmented way to learn. And often we go to the board meetings and we say, well, what have we done in the past? Should we do that again? Should we do it the way we've kind of been doing it? So there's much better ways to learn about HOA management. So my first recommendation was that there should be in statute an education standard for board members like us. And it would need to be worked out to be a reasonable sort of thing, but it would be a baseline of education that really is going to apply to all of our HOAs. Secondly, there should be a grievance process so that the complaints that are coming to this work group are ones that they've been unable to resolve in their own HOAs. So it's been such a grievance process, or they can't resolve it within their HOAs, so they call the Attorney General or they call their legislator. And there's no formal way of managing those complaints and helping to bring them to some kind of resolution. And often the complaints that are coming from the homeowners, they're not correct. It reflects that they don't understand what the board is responsible for doing and what authority the board has. So a homeowner might be making a complaint, but the board is actually doing their job. They're actually doing their duties. But the homeowner doesn't understand that. They don't understand what the board is able and responsible to do. There is a certification program at the national level through Community Associations Institute for association managers. In 2023, there were 189 certified association managers in the entire state of Minnesota. So think of there's like 80 some management companies in the metro area alone. 52 of those certified managers were with one company, First Service. So there's a opportunity for association managers to be certified and to be well informed and educated about their role as an association manager. Fourth thing I recommended was that all of us register our associations with the Secretary of State. That is a poorly maintained database. It's accurate only to the extent that somebody logs in and updates the name of the association president. And often it's not even the name of the president, it's the name of the management company. So it could be a useful data set, but it is not now. And then finally, strengthen the regulatory ability of the Department of Commerce to regulate our HOA master insurance, which it does seems to fall under the purview of the Department of Commerce, but they really don't have much oversight or authority over us, and we're designated as commercial insurance. So there's been some question whether we should be residential insurance instead of commercial. So those were the recommendations I made. Again, there'll be opportunities for any of you, if you're interested, to make comments to the work group. They'll meet, as I mentioned, they'll probably meet, they might meet again in December and then in January. And that I did understand there's a possibility it'll be extended because it's just not realistic, I don't think, to look at making recommendations within like 6 months here to change the statute of the MCIOA. So it's probably going to be an ongoing story. But it is really quite important. I mean, the law will regulate how we operate our HOAs, so it's going to be pretty important to, if you have comments to make, they would be very interested in hearing them. And I tried to position us as good, I mean, as a good place to live. HOAs can be a very good living situation, but there's opportunities to make it better